In this video, I am covering trade secret law. This is the fourth video in my series on intellectual property law. Previous videos covered copyright, patents, and trademark. If you're interested, those videos are linked in the description below. My name is Konrad, and I'm a practicing attorney here in Chicago, Illinois. On the subject of trade secret law, I have probably litigated more trade secret cases in my career than any other type of case. In fact, I have litigated more trade secret cases than the vast majority of intellectual property attorneys. In addition, my firm counsels numerous companies on trade secret issues, so while trade secret law is one of the most complex and mysterious areas of law, this is a subject that I know very well. Trade secret law encompasses a complex patchwork of state and federal laws that weave together to provide trade secret protections. However, the basic concept is straightforward. Businesses are always working on improving the way they do things, and sometimes they come up with significant advances in processes or know-how that give them an edge over their competitors. In some cases, businesses can file for patents, but in other cases they may choose not to file for a patent, or the improvement may not meet the test for patentability. See my video on patents if you're interested in that subject. In any event, as long as the secret is of economic value, and the business takes reasonable steps to keep the valuable information secret, the courts will protect that information as a trade secret. Now, the first thing that might come to mind is, why do courts protect trade secrets? A business can just apply for a patent if they have something novel and non-obvious to offer, and in that case, the company gets a monopoly for 20 years, and the public gets the knowledge. So why provide any extra protection? To cut to the point, think about a business hiring someone, training that person, and then paying that person a salary or a wage for a few years. If that person then goes to work at a competitor and takes the business's valuable trade secrets with them, think customer database, marketing plans, product designs, and so on, is that fair? I don't think so either, and that is why trade secret protections exist. With the why question out of the way, the next natural question is, what exactly is a trade secret? The long answer can be found in the various federal and state trade secret statutes, but from a high level, a trade secret has to meet the following test. 1, it has to be information. 2, it must provide a competitive advantage. And 3, it must be the subject of reasonable measures to maintain the information as confidential. I could spend a video on each of these, as there are many articles written on what can be and cannot be a trade secret, what kind of competitive advantage has to be present, and what kind of steps have to be taken to keep the information confidential to maintain trade secret protection. But we are only going to touch on these subjects briefly. About the information, almost any kind of information can be a trade secret. I have litigated a lot of trade secret cases, probably more than any other type of case, and I would say that the most common kind of trade secret that I have seen are customer lists and sales and marketing techniques, meaning the procedures that businesses use to identify potential customers, present to, and sell to those customers. Lots of companies think this is valuable information and seem to be willing to litigate over it. There are plenty of other easy examples as well. Technical information, product testing information, source code, internal lists of phone numbers, employee contact information, what have you. As far as a competitive advantage, anything that provides economic value can meet this test. It does not have to offer an enormous edge, a slight edge will do. And the edge does not have to be in any specific area. Making a product at less cost is just as legitimate with regards to trade secret protection as making it last longer. Finally, the measures that have to be taken to keep the trade secret confidential is one of the more difficult tests to meet. Proof that the so-called trade secret is generally known will destroy any trade secret. But the bar to fail this test is a lot lower. To sum this up, if a business wants a court to treat information like it is a trade secret, then the business better treat it like a trade secret and be able to prove that it treated the information like a trade secret. Taking no extra steps will pretty much always result in the information being judged not to be a trade secret, and treating all information at the company the same generally is not good enough either. To prevail on the secrecy requirement of trade secret litigation, the business generally needs to show that it took at least some reasonable steps to make the trade secret information stand out from other information. Mark it as secret or confidential, restrict access to only a few employees, and so on. So we now know why trade secrets exist and what a trade secret generally is. How about trade secret lawsuits? How do they come about? The formal name for a trade secret claim is trade secret misappropriation, which requires that a person either acquire a trade secret through improper means or improperly disclose or use a trade secret without the consent of the trade secret owner. The word improper is mentioned a few times, and improper means are important to the trade secret analysis. So what are improper means? How about if the trade secret is discovered by someone else? They didn't have access to the trade secret information from the owner. They just experimented until they stumbled on the same trade secret that the owner wants to protect. That is a classic example of what is not improper means. Trade secret protection does not stop anyone from discovering the information on their own and then making use of it. Only a patent can provide that kind of protection. Similarly, if a competitor takes a product apart to determine how it works, that is not improper means either. What that's called is reverse engineering, and it's perfectly legal. How about if an employee works for the trade secret owner for 5 years and is exposed to the trade secret information almost every day? Let's say it's a way that concrete is mixed before being laid down. And after those 5 years, the trade secret owner runs into a rough spot and has to lay the employee off. The employee is lucky enough to find another job at another concrete company where the employee starts to use the trade secret and tells other people at the new company about it. Is that an example of trade secret misappropriation? This fact pattern is a much tougher call, but I would argue that most courts, not all, will say yes, that was trade secret misappropriation, as long as the concrete mixing technique was clearly designated as a trade secret within the original concrete company. Finally, there is the classic case for trade secret misappropriation, the facts that pop up in case after case. An employee works for an employer for a while and then decides to pursue another opportunity. Start his own company, organize a mass defection to a competitor, what have you. Right before he leaves, he copies tons of company data, customer lists, operating procedures, what have you. And at least some of that copied information was restricted to only a few employees at the company, and some of it was marked as secret. That scenario is the classic case of improper means. Copying the trade secret with a clear intention to use it at your next gig is pretty cut and dry, and it will get you into a lot of trouble. Now, if a trade secret owner wins a trade secret case, then the trade secret owner can recover damages and obtain an injunction. In addition, many trade secret statutes have attorney's fees provisions, which can make a huge difference in being able to afford a case. A lot of law firms will factor the attorney's fees provisions into their fee proposals when they take a case on, which can make a trade secret case much more affordable for either a plaintiff or a defendant, depending on the merit of the case. One more point about trade secret law that merits discussion is how long trade secret protection can last. And the answer is until the trade secret is no longer secret, which means theoretically forever. There is a lot more to talk about with trade secrets, including the differences between the Defend Trade Secrets Act, that is the federal trade secrets law, and the Uniform Trade Secrets Act. Most states have implemented a version of that latter statute for their trade secret statute, as well as other related statutes like the Computer Fraud and Abuse Act and how things like restrictive covenants play into trade secret cases. But that is all I'm able to cover in this video. I'd be very interested in hearing what your experiences with trade secrets have been and what kind of questions about trade secret law you might want to see me address in future videos. Does your company make you sign an NDA because of what they claim are trade secrets? Are you actually a foreign secret agent here on assignment to steal trade secrets from U.S. technology companies? If so, leave that out of the comments because I don't want the CIA breaking down my door. Anyway, if you learned anything from this video or found this video entertaining, a like would be appreciated. And if you are interested in more videos like this in the future, feel free to subscribe and turn on notifications. Have a fantastic day.